Yeah. I don't know. I see him do it, so I'm doing it. You know? David. David. See, I learned the wingspan, see? It's all good. Okay. All right. No, we're on. I already took care of it. Okay. Okay, good evening, everyone. Welcome to the Hillsborough Township Planning Board meeting of October 9th, 2025. Please join me in a salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2025 annual meeting schedule has been provided to the officially designated newspapers, Township Clerk, posted on the Township's website, and available here at the Hillsborough Township Municipal Complex. In addition, application documents and plans have been made available on the Township's Civic Clerk website at least 10 days prior to this evening's meeting. Complete application files are available in the Planning and Zoning Department for inspection in accordance with the public meeting notice. With that, may I have roll call of board members and also board, oh my goodness, board and township professionals, please.
Mr. Wagner, Mr. Radowitz, Mr. Deb, and Mr. Smith are absent. Mr. Flagg?
Here.
Mr. Vitale?
Here.
Ms. Smith?
Here.
Committeeman Lapani?
Present.
Mayor Chigarelli?
Here.
Vice Chair Peason?
Present.
Chair Sirachi?
Here.
Mr. Cloyce?
Present.
Mr. Bernstein?
Present.
Mr. Mayhew?
Here.
And myself and the videographer are here.
Okay, welcome everybody. So we do not have any meeting minutes for consideration. However, we do have a resolution for consideration. See Homestead Road LLC, file number 21-PB-25-MS/MSPV. Is there anyone that wants to present?
Eligible members are Mr. Peason, yourself, Committeeman Lapani, Board Secretary Smith, and Mayor Chigarelli.
Okay, thank you. May I have a resolution to, may I have a motion to approve the resolution?
So moved.
Second.
Okay, any discussion from the dais? Hearing none, roll call, please.
Ms. Smith?
Yes.
Committeeman Lapani?
Yes.
Mayor Chigarelli?
Yes.
Vice Chair Peason?
Yes.
Chair Sirachi?
Yes. Okay, we don't have any planning board business, nor any considerations of ordinances, so I will now open up to business from the floor for matters that are not on this evening's agenda. If anyone would like to come up, please come up to the microphone, state your name and address for the record. I don't know.
David Brook, Winding Way. I feel very lonely that I haven't been coming to these meetings, and I wanted to say hi, so I figured I'd just come by and thank you all for doing the good work you do. I have a question that relates to Harvard Way. And since the attorney who's representing them is here, it seems appropriate to ask. I know I can't ask next week because it's on the agenda. It's basically this: do you know if the public will have an opportunity? It's the remand, I guess I should say that. Will the public have any opportunity to comment on the discussions that are going to be taking place?
First of all, and I'm sort of jumping the gun, the hearing will not be next week for two reasons, and I'll mention this again later. One, counsel for the board, other than myself, father actually just passed away, so she will not be available. And in the interim, we have gotten notice late this afternoon, correct me if I'm wrong, from Judge Menon that he wants to hear oral argument on the intervener's appeal to intervene in the board hearing on next Friday afternoon. So for those reasons, it will not be on for the 16th, and not sure when it will be. It'll depend on probably now what Judge Menon does. As to the answer to that question, we may get some direction or not from the court.
Thank you.
Well, sorry, but the question still stands, I think. When it does eventually come,
will the public be able to, unlike me,
At the
comment on it?
moment, the public, I don't believe, is going to be allowed to comment, except possibly on what came before the board through the presentation from Mr. Flynn. But again, that will depend on, I suspect, what Judge Menon does, depending on what he does with the intervention motion.
Thank you.
It will be an issue that will get raised. We have raised everything else, as I think Mr. Ogrodnik will concur. So why not add that one to the long list? So,
So you'll have to come when it gets rescheduled and find out.
And I may be jumping the gun by asking the order of business of how that proceeds, but presumably the discussion in the remand indicated that the planning board would conduct deliberations. I don't know if that was the exact word, but something close to that. Do you have a sense of how that plays out from the point of view of going through the different points that the judge has
I would
provided?
advise the board not to respond. It's an ongoing litigation, and the board will be advised accordingly at the appropriate time.
This is something new for all of us, so I think we're going to learn all together.
Well, exactly
yeah.
that, and it's new to me, so I just figured I would ask if anybody had a sense of it. I wasn't asked by Mr. Ogrodnik to come up here and ask that question. I just want to know that on the
Actually, I don't think
record.
Mr. Ogrodnik wanted you to come up and ask that question or had any interest in the answer.
All right.
I know I'm well aware of what his position is.
Thank you.
Thank you. Okay. Any other members from the public? Okay, seeing none, we will move to this evening's application, public hearing, Green Care Farms LLC, file number 24-PB-09-MSV, time of decision of December 31st of this year. It's Block 204, Lot 45.01, commonly known as 241 Woods Road. The applicant is seeking preliminary and final major subdivision approval, see bulk variances and waivers to subsidize 12.28 acres into 5 single-family dwelling lots with associated stormwater improvements on the property located in the residential agricultural zone. The application was adjourned from the September 11th, 2025 meeting without further notice. And with that, I will turn it over to Mr. Ogrodnik.
Thank you. Ladies and gentlemen of the board, Mike Ogrodnik, Savo-Shalk Law Firm, on behalf of the applicant Green Care Farms, LLC. As indicated in the preamble, it's a major subdivision. We're intending to seek approval for the construction of 5 single-family homes. This is Block 204, Lot 4501. It's located at 241 Woods Road. In short, there's a lot that is 12.2 acres. It's an irregularly shaped parcel in the residential agricultural zone where single-family dwellings are permitted principal uses. This application proposes 5 dwellings with associated driveways, drainage, 3 large detention basins, utility improvements, and landscaping. This area of the township is, specifically this lot, it's vacant, it's wooded, and it's a tract that's surrounded completely by other single-family homes. It's bounded by, of course, Woods Road to the east, and then residential properties along Lanning Way, Fairfield Lane, and Petrick to the south, north, and west. This property was subject to approval on September 9th, 2021 for a dementia care facility under 19 PB 21 SV. That is no longer a feasible project, so we're moving towards 5 residential lots. We intend these to be custom homes in the $1.5 to probably $2.3 million range. Concept plan provides for shared driveway for lots 45.07 and 45.08 to be constructed in rural lane standards under the RIS as opposed to a public roadway. We have on file DEP LOI confirmation, absence of wetlands, dated August 10, 2021. Variances, I'm going to go through the variances that are currently proposed and then just touch on a concept plan that was the result of communications with your professionals and collaboration with your professionals. But as it stands now, the lot width setbacks for lots 45.07 and 45.08, 200 feet are required. We're at 87.4 and 82.59 feet. A lot area is 2.11 acres, where 3 acres are required. And then the access drive variance for the shared driveway serving multiple principal uses. There's also a tree mitigation variance identified by Mr. Coyce's memo from relief from 188-163. And I found out that your economic hardship waiver is no longer applicable as eliminated by ordinance 2024-16. With respect to the relief, the applicant can eliminate the variances by constructing a public roadway. Looking at the site plan to the north 2 lots, which is lots 45.07 and 45.08, which would allow for the appropriate frontage and area. However, we've reviewed comments and we've had discussions with the professionals, and Mr. Ford has prepared an exhibit tonight that he'll detail. That's a labeled concept plan that was submitted that would still not have the public street in order to eliminate the relief, but would have a driveway that would be a shared driveway, but constructed under our SIS rural lane standard, so wider. I think it goes 12 to 18 feet. He'll detail that. But it does. I think the major change here is just single driveways out to woods for the other properties. So there wouldn't have that access drive variance under 188-49E, except for, again, those 2 lots looking at the site plan to the north. I have Mr. Ford, Michael Ford, our civil engineer, and we have Tom Behrens, our professional planner. We also have Raj Singh on behalf of the applicant available to answer any questions. And we would ask that Mr. Ford be sworn in, qualified as an expert, and present his existing proposed and concept plan.
Swearing testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
For the record, can you state and spell your name?
Michael?
There you go. Michael Ford, F-O-R-D, licensed professional engineer and planner in the state of New Jersey. Been with Van Cleef Engineering for nearly 35 years, and I've appeared before this board numerous times.
Yes, we know.
And no new grandchildren since my last visit in
Okay.
June or July. Yeah. Okay, all right.
Okay, we accept.
So perhaps we emailed these exhibits to the planning department this afternoon. I'm going to refer to 4. First is a plan entitled Existing Condition Exhibit. That's dated March 14th, 2025. That's what you see on the screen right now. It's,
Mark, this is A1.
yes,
Date on it, Michael?
March 14th, 2025.
Thank you.
And I have a hard copy I can give to whoever. Okay, here we go. Just keep one. Yeah, there you go. And perhaps I can enter, there's only 4 exhibits, I can enter them all, and then as I refer to them, then we'll. The second exhibit is a plan entitled Proposed Condition Exhibit, again, also dated March 14th, 2025. It's a colorized exhibit of the proposed condition,
Date on it,
March 14th, 2025.
A2.
The third is again also entitled Proposed Condition Exhibit. It is dated October 9th, 2025.
A3.
And then A4 would be a preliminary plat, and I'll scroll to it. dated October 11th, 2024, last revised March 21st, 2025.
A4.
And as Mr. Ogodnik indicated, this is a single-family residential major subdivision to create 5 new building lots on 12.3 acres. We're in the RA zone where the minimum lot size is 2 acres. And I think it would be rare for this board to see a situation like this where we have such large lots, that is 2 acres. Normally, that's the minimum lot size for a property that doesn't have access to public sewer or water. However, in this case, we do have access to public sewer and water, and all 5 lots would be serviced by public sewer and water. The overall average lot size is 2.5 acres, and as was discussed earlier, we have some relief associated with the application. However, as part of my presentation, I'll describe to the board an option that would be a completely compliant layout for the bulk standards, that is, eliminate the lot area, lot width variances, as well as the shared access relief. However, after discussions with your staff, I would hope that you agree that the public road for just 2 single-family lots is not a better planning alternative, and the project as proposed with the relief would be a better planning alternative. And I'll go to that now. So the next A2 is an exhibit illustrating the application as has been submitted. I'll refer to the left and right side of the plan, which is the left side is the west side, right side of the plan is the east side. Fronting Woods Road, just opposite Petrick, is 3 proposed lots, which I'll refer to the east side lots, those 3 lots. As we had initially submitted the application, we actually thought that there would be a preference to limit the driveways on Woods Road, so we proposed a shared driveway access. After discussion with your professionals and understanding the relief associated with that and the review memorandum we received from the board engineer back in September, we've prepared an alternative plan that, as Mr. Ogodnik indicated, would be separating all 3 of those driveways as has been suggested by the board engineer. And while I'm in that area describing that, I'll flip the screen to A3 and you'll see the substantive change. Literally just splitting those 3 driveways so each house would be serviced by an independent driveway. And that would eliminate one of the relief aspects that was part of the original application to have a shared driveway for those 3 properties. The second aspect is with regards to the westerly lots, the 2 lots at the top left portion of the application. You'll see in the exhibit, and I'm back to A2, which is as was submitted layout. You'll see, and I'll flip to A3 now with the slight change over there. The shared access driveway was part of the original submittal would be widened to those rural lane residential site improvement standards, and the access lane would be widened. While I'm describing those lots in that westerly side, I'd like to flip to A4, which is an illustration of the completely complying plan with the new public road. And you'll see that the new public road, or even if it were a dedicated private road, would still service just those 2 lots, those 2 houses, make the bulk standards relief go away for those 2 lots. That is the lot area and the lot frontage, so they would be completely complying. But in essence, you would still have the same resulting development with a higher burden of improvements to maintain, albeit by a dedicated township road. And I know the town wouldn't be looking preferably to, especially a private or a public road for just two houses, or even a private road that would be owned and maintained by a homeowner association. And we feel it's a better planning alternative. And I believe the report that we received 2 days ago from the board engineer also supports this, is that rather than this public road option that would eliminate that relief, is to simply take the original proposal, widen that driveway to service those two lots to meet RSIS standards, and widen that easement. So that's the substance of the bulk standard relief. And as Mr. Ogrodnik indicated, we have a professional planner with us today that will go even into more detail with regards to that relief. But I think the board can see quite easily with the flipping back between the three different exhibits that the option to eliminate the relief really doesn't substantively change the proposed 5-lot, single-family project, but would have a much higher burden on whoever it is to own and maintain some improvements. Okay. Stormwater management. I've talked about utilities, public sewer and water. There's public water in Woods Road. The sewer would be brought in from Woods Road into the service all 5 lots. With regards to stormwater management, you'll see on the exhibit A3 that I have up now, which is our proposed project now with the separate driveways for the 3 easterly lots and the 1 shared driveway access that would remain and still require relief for the 2 northwesterly lots. We're proposing 3 detention basins for 5 lots. These would be bioretention infiltration basins. So the detention basin would service both or all 3 aspects of stormwater management as required by state code, the town code, and other regulatory agencies. That is quantity, quality, and recharge element. For example, all 3 basins have the water quality element, and for the water quality storm, which is that first flush storm, the water quality treatment would be done in all 3 basins, and there actually would be 0 discharge from the basins for those water quality storms, and that would be accomplished by infiltrating through the filter media and the bioretention system to provide for that water quality treatment. Then quantity and quality are, again, addressed by the bioretention basin. These would have outlet structures at each basin that would release the inflow into the basin at a controlled rate such that the peak discharge from the basins not just are below existing conditions, but as required would be below the peak rate of existing condition for the 2-year storm, 10-year storm, and the 100-year storm by 50%, 75%, and 80%. And within our stormwater management report, we illustrate, again, we're dealing with the new stormwater rules now, so it's the new rainfall data, it's both the present adjusted and the future stormwater rainfalls. So, for example, the 100-year storm, while it was a 8.2-inch rainfall event within 24 hours that we were designing for not too long ago, the new standards are approximately 12 inches of rainfall for the future 100-year storm. These basins are designed to accomplish those reductions, and in virtually every aspect, they don't just meet those reductions, but meet them by a comfortable conservative margin. This has been already reviewed and established the compliance with the stormwater rules by virtue of our approval letter that we received from the DNR Canal Commission. We also have a approval letter from the Somerset Planning Board. We just would have to address their conditions for filing the major subdivision plat at the county clerk's office. And we also have secured the Somerset Union Soil Conservation District approval. Regarding trees and tree mitigation, as Mr. Ogodnik indicated, and this is reflected in the board engineer's review dated October 7th, we're now aware that the code has changed, that the economic hardship waiver went away. The original application that was submitted actually about a year ago for this project, and it obviously took some time to get where we're at now. The code has changed since the original submittal, where we did request the economic hardship waiver. We've reviewed the new standards with both the township staff and the applicant, and we would comply with all of the planting standards. So that is the tree mitigation plantings that will be required as part of this application in accordance with the current new ordinance will be complied with. The one aspect of the ordinance that remains, and it was part of our initial application for relief, and it still remains in the current new standard, is that for, in addition to the tree mitigation, there's a requirement that for residential projects, you not disturb more than 20% of your total wooded area. In this case, and you saw by virtue of our A1 exhibit, that this site is substantially wooded, majority wooded. So to comply with that 20% reduction would be a hardship, especially when you consider other factors that are also in the regs and kind of conflict with that disturbance of wood requirement. And I'll point to first the stormwater management aspects. You'll see that the 3 basins that are highlighted on A3 in lighter green encompass substantial areas. They have to be placed at low ends so they gather the stormwater, by gravity to flow to it. And they also happen to be in areas that there are some existing woods. So the woods would have to be disturbed in order to build the detention basins. The other aspect is when you look at the zoning, the building envelope is set by the property lines and the setback requirements to the property lines. So we have some that obvious restriction in order to comply where the houses are located, and that also happens to be in wooded areas. So we're right now, as illustrated on our tree mitigation plan, disturbing approximately 52% of the wooded area. What I'd like to highlight, though, is right now, and there's been some, and I'll get to in a minute, the most recent review memorandums are going to require some revisions to the plans. So obviously there may be some changes subtly to the areas of disturbance and therefore the mitigation and the tree disturbance to comply with what we've been asked to do. But the initial application carried with it a disturbance of removal of 329 trees. Our preliminary calculations based on the current tree mitigation ordinance would include a tree planting in excess of 400 trees for this project. So you can see by virtue of the math and the tree mitigation requirements, the resulting plantings will be in excess of what the individual tree removals are. And we will endeavor to plant all the trees on site, and those areas that might not be slated for development, might be open now, we would endeavor to fill in those gaps to create greater wooded areas. So while we exceed the limitation for the percentage of tree mitigation, we're also, as a result of the mitigation plantings, going to be bringing back some of those wooded areas. Perhaps now I can go to the review memorandums. We are in receipt of a July 22nd, 2025 review memorandum from the township's Fire Marshal, Chris Winiger. There's 2 bullet point items, and we would agree to any condition of approval this board may grant to comply with those requirements to Mr. Winiger's satisfaction. And I'll get to it in a minute. The board engineers October 7th memorandum a couple days ago included also a requirement that we comply with Mr. Winiger's requirements, and in both places, we would absolutely agree to do that. As part of this application process, we made a visit to the Environmental Commission. There's a September 10th, 2025 memorandum to the board from the Environmental Commission. They're primarily bullet points that state facts, and to the extent that the Environmental Commission suggests some changes or items that we should address, we would agree to do them to the satisfaction of your board engineer, so that where they coincide with or are collaborative with the board engineer's comments, which we'll get to in a minute, we would agree to do that as well. For example, a deed restriction over the proposed stormwater management basins. I believe that's consistent with what the board engineers already asked for. That we don't clear the site or do the removal of trees to respect potential bat habitat. Those types of items we would agree to do. 2 more memorandums I'll speak to. A September 8th, 2025 review memorandum by Mr. Koist, the planning director. And there are, under planning zoning considerations and comments, 15 comments. I'm hoping that I've been asked to provide some testimony and explanation about that. I've done that as part of my presentation so far. We defer to Mr. Koist if there's something that remains to be addressed, but we would agree with regards to any item within those 15 comments where there's plan changes to be made to do them to Mr. Koist's satisfaction. Then lastly, an October 7th, 2025 memorandum by Pannoni Associates, the township and board engineer, Mr. Mayhew. There's 7 pages. Again, there's quite a bit of detail and elements of changes or clarifications on plans, and we would agree to do every item in that review memorandum to the board engineer's satisfaction. We have no objection to any of those comments. And perhaps maybe I can speak to just a few if there's items where I missed with testimony. For example, I've already highlighted that the original application included relief for the shared access driveway for the 3 southeasterly lots. As suggested by the board engineer, we would eliminate that by separating those driveways. With regards to the widening of the shared driveway to proposed lots 4507 and 4508, the northwesterly lots, we've agreed that, and I've already discussed it, that we would widen that and comply with the engineer's suggestion. As we've, just to remind the board, at part of our initial presentation, there was a freshwater wetland presence absence, and that is a determination of absence of wetlands issued for the property. So there are no wetlands or wetland buffers on the property. And that's been verified by NJDEP. With regards to the additional comments in the October 7th review memorandum, as since the initial September review memorandum, there's additional details and expanded stormwater management analysis that the board's engineers requested, and will comply with all of those requirements. That is being said, in addition to what I've already described, where the stormwater management aspects of the project have already been determined to be in compliance with the state regs through the DNR Canal Commission, but to the extent that the supplemental analysis includes some additional stormwater mitigation, we would make that part of the plans and project to Mr. Mayhew's satisfaction. And these, I think, are also, I'll say, good neighbor suggestions where we're already going above and beyond the regs by providing reductions in the peak flow substantially below and not just close to what the regulations require, but to the extent that there can be additional mitigation measures made. Spreading out the discharge from a basin is one of the items that's suggested, and I'm just highlighting these for the board's information. We have no objection to doing those. Perhaps I can stop now, and we've made application to the HTMUA for the sewer extension. We're in receipt of a will serve letter from January of this year and have received recent comments from the Sewage Authority, which we'll address, and that's an independent agency, and we understand that we would need HTMUA approval, Somerset Raritan Valley Sewage Authority approval for the public sewer for the 5 homes, as well as NJDEP approval for the sanitary sewer extension. I believe that's it.
Mr. Mayhew.
Thank you, Mr. Chairman. Based on Mr. Ford's testimony that his office would agree as a condition of approval to address our October 7th comments, I have no additional comments or questions.
Okay. All the pressure's going to be on you.
Well, we've spoken, Mr. Ford and I have several times prior to the meeting and discussed some of the more pertinent comments.
Right.
And based on his testimony tonight and earlier comments, I believe our office, or I believe his office, will be able to submit plans that will address our comments.
Perfect. Thank you. Joyce.
Thank you. Mr. Ford, just verification, the comments that I provided, you had said you agree with the ones that were made, or were there any that you won't be able to comply with?
No.
Okay. That's all I have, Mr. Chairman.
Okay.
Thank you.
Thank you. Board members.
Mr. Ford, congratulations again. 3 questions regarding, sorry, get closer, mostly the stormwater, because I haven't seen any real plans here. Can you explain why there, for the one lot, I guess lot 4501, there's no stormwater detention base or anything for that lot, where the other 2 lots have them, and obviously the ones to the north? Are we draining 4501 down to the other biodetention basins?
Correct.
Is that like through piping, or?
Yes, there's lawn inlets, and it's the way the grade of the site is, that's where the flow we go to.
Okay. Secondly, the detention basins, what's the depth of those? Are
The
they-
depth of the
I mean, like,
basins?
are they 4 feet, 5 feet, 10 feet?
Yeah, no, they're like on the order of 4 or 5 feet. They're not, none of the embankments are to extent where they would warrant a permit from DEP for a dam, for example. They're not They're not that high.
So there are mowable slopes, or as far as from a maintenance standpoint, are
The basins in the southeasterly corner are just gentle, like 3-to-1 slopes, so they would be maintained that way. In order to accomplish the volume we needed to restrict the outflow from the 2 lots on the northwesterly corner, the top lots, that basin does have a retaining wall in it.
And
So the outside of the basin drains, has a gentle slope, the inside has got a wall.
are they fenced?
Yes.
Okay. And my last question is, are they an engineered basin, meaning that they've been for perk, that they're utilizing a sand base or some sort of filter that will allow, because obviously there's no outlet, right? They just come in,
No,
gather
they're-
water and soak, or where, if they
Yeah,
overflow, is there an outlets?
Yeah, they all have outlets, and they all have, an outlet structure that controls the outflow. But they are, we've done soil testing at all 3 locations, and these are, the sand bottoms you refer to are really like a plain infiltration basin. These are bioretention, so they'll have vegetation in the bottom, so they'll look more natural. In fact, one of the comments in Mr. Mayhew's review memorandum speaks to the type of vegetation they'd like us to put in those basins.
Right. So they're, from a maintenance standpoint, and the HOA and doing the maintenance, is it a low-maintenance situation where it's just, they have to keep the outfalls clean, Mr. Mayhew? I mean, what kind of maintenance are being required? Because I'm just worried about them not being in good shape and then they start to fail,
Right.
is my concern.
Yeah, the stormwater regs, in order to comply, mandate these types of structures. The type of basins that we're proposing, I believe are, I'll say, more user-friendly in the sense of maintenance, because the vegetation in the bottom of the basins would look attractive, but also not require a lot of maintenance. There is an operation maintenance manual that we prepared and submitted as part of the original application, and some of the comments we received is to add more data to that. And there will be a requirement that gets recorded, so any person that purchases a home in here will know of these responsibilities. And part and parcel, the town actually, the township has a requirement that there's an annual reporting of an inspection.
Correct.
But all that said, we're all human, so it's going to be an ongoing challenge to have stormwater mitigation, but have the ownership and maintenance responsibilities adhered to.
So the basins, I'll call it the bottom of the basement, are going to be planted, right? So it won't be all open grass. It's going to be the infiltration system with plants and vegetation to absorb the water and filtrate?
Correct.
So there's no mowing and that kind of
Correct.
thing? Okay. That was kind of where I was trying to
Okay.
get to for his maintenance standpoint. And lastly, I didn't notice, is there any kind of these long driveways, any kind of lighting that's included for safety in any of these driveways, especially the long common one, like
Yeah.
a traffic light or a one-pole light at or something?
We haven't proposed any lighting, like as if it were a site plan.
Okay. That's all.
If I may, on item 6 of the planning report, which I shut down, is there any way we can either do some deed restriction on the trees that are remaining? I think it relates to that these are going to be sold as individual lots to be developed. So this is either for Mr. Ford or for anybody on the dais. And the reason I say this is we've had recent experience where one of these types of developments is started, and they just clear as much as they want. And come back to say, oh, I'm sorry, we went 20 feet too far, we cleared to the line. So a deed restriction was mentioned on the stormwater detention areas, but what about all these trees that are in between them? can we do something to make sure that they don't get clear-cut by an owner? And I know we have ordinances, but that doesn't stop people from doing it. I don't know if we can require that or not. Anything outside of the yellow marked, the lines of disturbance should never be touched, right? I'd like to see that, if that's, I don't know if that's been heard of before, if it's even legal. Or wondering if our construction department has to be diligent when the time comes. So I kind of throw that out to everybody.
I mean, typically, we wouldn't want a deed restriction. I mean, if there were wetlands, if there were other regulated, other sensitive, environmentally sensitive areas, that may be appropriate, but this is forest. Those deed restrictions are quite stringent, and I don't think really appropriate for a single-family home. But certainly, there's two mechanisms of enforcement. Of course, you mentioned the ordinances, and I'm cleaning up that mess on that project that you're talking about. I did not handle that application, but I'm aware of that. But you also have the conditions in the resolution that can spell out, the areas that shouldn't be disturbed or a limited disturbance without having the necessity for a deed restriction. So we would ask just that it be incorporated and detailed in the resolution.
Okay. And this one may or may not be appropriate at this time, but because I think this is actually probably for the planner and not for you, Mr. Ford. But item 11 discusses the affordable housing development fee. So it was in David's report, but I think it's not for Mr. Ford. So I think we'll wait till the planner gets up there. So, all right, thank you.
All right, thank you. Any other board members? All right, may I have a go ahead.
I just have one quick question. In the Pannoni letter, number 5, it talks about the rural street parking. I just am curious, how are you going to address not having any parking on that rural lane?
Sure, yeah, okay. The expectation would be that these would be 4-bedroom homes or larger. The residential site improvements standards require, for a 5-bedroom house, for example, 3 parking spaces. But a 2-car garage with the driveway behind it, they give you credit for 3.5 spaces. So just by default of having the 2-car garage with the driveway complies with the RSIS standards for parking. But to your point, like the idea of having visitors, I think that that's a balancing act, right? We don't want to create a big parking area that never gets used or gets used once in a while. I think from a practical standpoint, if there's a, I think an acknowledgement, if there's a family event where they have multiple people there, they would be parking along the driveway, or right at the house on the lawn, right? We wouldn't have a special parking area for that. And they also would have to comply with the point you're making, and I think the point that's made in this review is that there's no parking allowed on Woods Road.
So just to clarify, does that mean you would put a sign or something?
I'm not sure that there's not signs already along Woods Road, or yeah, there's not. I guess we could discuss that with Mr. Mayhew's office if there's a need for us to. There's other residents there already that would have to adhere to the same restriction.
Would that actually be spelled out in the deed, perhaps?
In the deed?
Just regarding, because since they're
Well,
gonna
we don't have
own, or is
authority
it
over a
HOA?
public right-of-way. So the township committee would have to do a study and impose signage. And I'm sure we wouldn't have a problem with donating the cost of a no parking sign along those stretches. But to the extent that, it's an enforcement issue, it's a different chapter of your ordinance. It's not in the land use and development ordinance, and any regulations on a public right-of-way must be governed by your police department. Zoning doesn't have authority over the public right-of-way enforcement. So, yeah, I would encourage you to review that portion of your ordinance and if appropriate, suggest additional signage that we would compensate the town for.
Thank you. I have one other kind of random question that I saw in, when I was going through the documents. So in 2021, it says that the DNR Canal approved a 10,000 square foot, 15-bed assisted living facility. I'm just curious, and I just want to know what was the change in thought process between, not going forward with that.
Just economically, construction costs tripled. So it became something that was not feasible. There was also market demand issues with that particular use that make that particular use no longer feasible.
Thank you.
I'm just going to go back. So now I'm just getting a little confused as to what is the rural lane? Is it the shared
Yes,
driveway? Okay. So that's going to be private, right?
correct.
Okay. That's why I was asking about Deaver, because it's not going to be a public road. I mean, it's a shared roadway or whatever between the two residents. I don't know if it's something that just gets embedded in the HOA so that everyone knows, they're not supposed to be parking. That's
Yeah,
why
I
I
mean,
was
it's
getting
private
at.
property. I mean,
Yeah.
if there's a graduation party, hopefully the neighbors wouldn't care that the other neighbor would park along that lane, but it's a significant length,
Right.
so you can probably adequately park a substantial amount, especially with the widening from 12 to 18 feet.
Right. Okay.
Mr. Chairman, if I could add one
Please.
point. I think Mr. Ford's done an adequate job explaining it, but I wanted the board to understand that our office hasn't taken an opinion one way or the other on the 3 eastern lots. Mr. Ford, if you could switch the exhibit, the original application had those 3 lots sharing one drive.
There you go.
There it is. And of course, that creates a variance for the multi-uses on one drive. So we had suggested to his office to then go to the exhibit, Mike, if you can move it over, where 2 of those lots, the driveways then directly access woods. But that's, in my mind, not an engineering issue. So I think that's something the board needs to think about and weigh in, whether it's appropriate to have the separate driveways or try to combine them. I guess I would add that certainly we've taken a quick look, but Mr. Ford, you should double check at the end to make sure there's adequate sight distance on that lot at the corner.
Yep, yes.
In our office opinion, it would more fit in with the other single-family homes along Woods Lane. They each have their individual drives. But again, that's more of a board decision, their preference.
All right, so just to clarify, so with regards, if these are going to be individual driveways or shared, that's something that's going to be left up to the board?
Yeah, I mean, the
settle?
applicant, actually, we agree with Mr. Mayhew that this is a better design. I mean, I think if you're building a $2 million house, you want your own driveway.
Okay. So the recommendation is individual
We
for the 3.
We take no exception to
Right.
that layout.
Okay.
And Mr. Chairman, if I could weigh in as well, from a planning and zoning standpoint, or at least what we experience on a daily basis, what I would say is certain circumstances, shared driveway is just gonna have to be something that makes a lot of sense. But when there's an opportunity to not have to do it, then you're eliminating the future issues of the property owners having civil matters with each other, which unfortunately we do experience. So when it is possible to do it, and especially when it's a road that is classified that you can still do curb cuts, and as long as it's being done in a safe way, this was an option that we were satisfied with seeing as opposed to the other one. But again, up to the board.
Yep.
Thank you.
that driveway that comes out onto Woods Road between the two S turns, obviously you have two blind corners, right? And you've kind of got the driveway, I guess, skewed more towards the one side. In your opinion, from a safety standpoint and sight triangle, coming out of that, would it make sense to move that more towards the middle so that you can have a better idea of what's coming around the turn? Because it looks like it's a big area, but it's not a very long area there. It's probably just a few hundred feet.
That's a great point, Mr. Lapani. Our office did a really quick look at, based on the speed limit and the required stopping sight distance. The key to note here is the right-of-way is extensive at that curve. So as long as the right-of-way is maintained, it creates an opportunity for a larger view. But I would certainly ask Mr. Ford on the final plans to show the stopping sight distances required on the plan, and both our offices will make sure that they're adequate.
Okay.
Agreed.
If no other board comments, can we have a motion to open to public, please?
So moved.
All in favor?
Aye.
Aye. Okay, if there's anyone from the public that would like to cross-examine Mr. Ford on his testimony, please feel free to come up to the mic, state your name and address for the record. Okay. So we have no takers.
That's the easiest thing.
It's all right. I'm wincing because I got a bad shoulder. Something's messed up here. I got to fix my shoulder. Yeah, okay.
So our final witness is Tom Behrens. He's our professional planner from Burgess Associates. Yeah, yeah, of course. Yeah. We're going to use your computer.
Okay.
Yeah.
Sure. Good evening, board members. My name is Tom Behrens, last name spelled Behrens. I'm a licensed professional planner in the state of New Jersey, as well as a member of the American Institute of Certified Planners. I'm with the firm Burgess Associates, located at 25 Westwood Avenue, Westwood, New Jersey. I've had the pleasure of being qualified previously by the Hillsborough Zoning Board of Adjustment, not by the Planning Board. I've been qualified by at least 30 other boards throughout the state, including closest to here would be Raritan, Somerville, Town of Clinton, and again, many others. And our firm also represents a number of municipalities where I represent those towns as planner, including zoning boards and planning boards.
Any objections? Hearing none, we accept. Please continue.
Appreciate it. Just to give an overview of what our office has submitted to date for this application, we've previously submitted a community impact statement dated April 16th, 2025. That document was prepared in accordance with Section 188-32E of the Township Code. It includes an analysis of the population, school, and fiscal impacts from the proposed subdivision. More recently, we've submitted a planning report dated August 28th, 2025, which includes a number of sections, including an overview of the site description, project summary, zoning analysis, overview of the applicable statutory criteria, basis for granting the requested variance relief, and planning conclusions, and I'll use that report as the basis for my testimony. With respect to the property description, I believe the board is well acquainted, but I'll just tick off a few notable points. One I'll note is that the lot is oversized with an area of 12.28 acres, where the RA zone requires a minimum lot area of 2 acres. So it's more than 6 times the minimum lot area requirement. The lot, I would offer, is highly irregularly shaped, where it has sort of 5 separate prongs. I was hard to come up with an analogy of what it might look like, a letter or some other shape. It's like a drag, I don't know what it is, but it's an irregular shape with at least 5 different appendages and 3 distinct frontages on Woods Road. It's impacted by one small area of steep slopes on the eastern area of the property where Woods Road curves. The lot's developed with 2 existing buildings near the center of the lot, including a 1-story dwelling and deteriorated 1-story frame structure. The remainder of the lot, as you've heard, is generally undeveloped and wooded, and there is also an area in the southern portion of the lot that has been cleared. Developments around this site, mostly single-family homes. There is some vacant land to the west and a qualified farmland to the south. You've heard about the application. I'll just note some other things that I think might be beneficial for the board's information. One, I'll note that there are 5 lots proposed, obviously, which range in area from 2.008 acres to 3.05 acres. Again, the overall lot size is 12.27 acres, which again is 6 times greater than the minimum lot area. As you've heard, lots 45.01, 45.05, and 45.06 will have separate driveway access on Woods Road, and lots 45.07 and 45.08 will share an 18-foot wide driveway with an access easement, which also extends to Woods Road. We're providing stormwater management. Each lot will be served by public sewer and water. And then finally, as you've heard, we'll be installing trees as depicted on the plans. These include street trees, screening for adjacent properties, and along 4 of the 5 proposed driveways. And as Mr. Ford testified to, we will comply with the entirety of the mitigation obligation on site. So in addition to what's shown, there'll be more trees as determined to be necessary and appropriate. With respect to zoning, again, we're in the RA residential agricultural zone, which permits detached single-family uses, which is what's intended for each of the 5 lots proposed. We're requesting 4 C variances as a result of the proposed subdivision. This includes the shared driveway access for lots 45.07 and 45.08, where separate access is technically prohibited in accordance with Section 188-49E, which indicates that only one principal use may be served per access drive. Second variance is for the non-conforming lot area of lot 45.08, which has an area of 2.114 acres, where a flag lot is technically required to have a minimum lot area of 3 acres. Third variance is for lot 45.08, which has a non-conforming lot width of 82.5 feet, where the zone requires a minimum lot width of 200 feet. Wasn't clear to me that lot 45.07 with a lot width of 87.4 feet requires a variance because it's more than 3 acres in size, and at that point, only 25 feet is required. So we can get to that, but it was unclear to me. We definitely, for sure, the one lot needs it, 45.08, but wasn't clear to me that 45.07 needs it. And I would offer, as you've heard, that these 3 variances are all related and primarily relate to the shared driveway, where we could conform with the cul-de-sac design, but I think, and hopefully we'll convince you that this is the better planning alternative that's being proposed. And then finally, we have the tree preservation variance, where up to 20% tree removals permitted, where we're proposing roughly 52% in certain locations of the site, but otherwise the subdivision is conforming. As I'm sure the board is well aware, the statute establishes a 2-pronged test for C variance relief, where one must apply either the C1 hardship test or C2 public benefits test. We also have to address the negative criteria, demonstrate that the granting of relief will not result in a substantial detriment to the public good, nor a substantial impairment to the intent and purpose of the master plan and zoning ordinance. Beginning with the first variance, with respect to the shared driveway access, in my opinion, both types of variances apply. I'd offer that the C1 criteria applies, given, again, the very irregular lot shape, which has 3 frontages on Woods Road. But I'll focus more on the C2 criteria and the planning and public benefits for this particular variance. The proposed subdivision, again, represents a better planning alternative to a new public cul-de-sac that would only serve 2 parcels. I would offer that the driveway as proposed is the most practical and least impactful alternative to providing access to those 2 lots. And again, requiring a cul-de-sac that only serves 2 residential lots would be, 1, atypical, and also excessive when there are viable alternatives to serve the same purpose. The driveway at 18 feet in width provides sufficient access and circulation for the two single-family lots in question. And I'll also note that this area of the lot actually has a width of 170 feet, where, again, flag lots of a certain size can have reduced widths of 25 feet, which, again, the point is to provide sufficient access and space from surrounding properties. And I believe the width of 170 feet achieves that for the driveway that's centrally located along the shared lot line. This configuration requires less disturbance and impervious coverage than an RSIS compliant cul-de-sac. It allows for increased landscaping as shown on the plans, as well as buffers for adjacent residential properties. It's certainly a more efficient use of the land and can be maintained privately through a proposed access agreement. And in general, I submit that the configuration functions well. Regarding the second variance, this pertains to the nonconforming lot area for lot 45.08, has a lot area of 2.114 acres. Again, it's noted that the RA zone requires a minimum lot area of 2 acres, but because of the flag lot configuration, technically 3 acres are required. I believe the C1 applies in this case also because of the irregular lot shape, but again, the C2 criteria should be the primary focus. The proposed design, again, better planning alternative. I'll repeat myself a few times. I'll try not to do it too much. And again, trying not to propose the cul-de-sac for the reasons stated. The parcel, again, speaking specifically about lot 45.08, has a very similar configuration to the adjacent lot 45.07. Both will function well. The design shows 2 conforming dwellings and associated improvements, shows the building envelope with adequate space from adjacent residential properties. The lot area, again, allows for conforming dwellings to be developed. Third variance, this pertains to the minimum lot width of 82.5 feet for lot 45.08. Again, reiterate that the lot in this location has an existing nonconforming width of 170 feet, which width will be maintained with a shared common access with a driveway of 18 feet centrally located on that portion of the site. I'll note that of the 25 parcels within 500 feet of the site, having frontage on Woods Road, only 6 parcels, including this site, have conforming lot widths of 200 feet. So as proposed, this configuration would be consistent with the surrounding character of the neighborhood. Again, better planning alternative. We could comply, but for the reasons stated, this is what we believe is the best planning alternative. And again, I would just submit that the lot has sufficient access and separation from adjacent properties. And then finally, the fourth variance is from the tree preservation ordinance. Again, we're only allowed to remove up to 20% of the existing trees on residential lots. We're proposing roughly 52%. However, I'll note that the proposed limit of disturbance demonstrates extensive preservation. If you look at the concept, those areas shaded in dark green represent the wooded areas to remain, which I mean, almost looks like the bulk of the property. I know we're saying 52%, but if you also take into consideration that we'll call it the southerly prong, if you look at an aerial map which doesn't have the design, it actually is a cleared area of the site. So both lots 45.05 and lots 45.06 take advantage of this cleared area and require less disturbance and tree removal for that reason. Believe both prongs of the statutory criteria apply. C1, because the lot is mostly wooded, so it's hard to develop the site and comply with that requirement for a site as unique and large as this particular parcel. But again, we'll focus on the C2 criteria as the tree removal is necessary to provide required stormwater management, which is a net public benefit, and that the strict enforcement of the 20% removal requirement would greatly restrict the development potential of the lot and render the majority of the site inutility. And I would also submit it would impose somewhat of an undue hardship from preventing the lot to be developed. The current plan depicts a total of 273 deciduous and evergreen mitigation trees. As stated by Mr. Ford, we will comply with the entirety of the mitigation requirements, if not exceeding those requirements. And as stated previously, the original approval for the 15-unit, we'll call it assisted living facility, also included the removal of 329 trees. So we're not too far off from that, but again, the mitigation I would offer would outweigh any removal. Regarding the negative criteria, it's my opinion that there'd be no substantial detriment to the public good from the granting of the relief based on our community impact analysis that was submitted to the board. There are no substantial population, school, or fiscal impacts caused by this 5-lot subdivision. The proposal will have the public benefit of removing dilapidated structures, the benefit of the installation of stormwater management where there is none, the installation of street trees, which would be an enhancement to the Woods Road right-of-way, as well as developing the lots in a manner that's prescribed by the zoning. So again, detached single-family zone, use permitted in the RA zone. There's a specific purpose stated for the RA zone and similar residential zones in section 188-98 of the Township Code, which states the purpose is to establish a distribution of population density throughout the township in relation to existing and prospective facilities, a convenient street system, employment areas, and reasonable predictability of population growth. The standards are intended to offer maximum flexibility in site design and the selection of dwelling unit types in order to offer a balanced housing pattern. So in general, the subdivision will result in lots and single-family developments that are consistent with the surrounding residential development. With respect to the master plan, we took a look at the township's 1996 master plan, which includes an objective that's specific to the township's residential districts and actually mimics the same as the purpose in the zoning ordinance. I won't repeat that. We also took a look at the township's most recent reexamination report dated 2018, which includes 2 relevant land use objectives, which include the township wants to continue and expand land use policies that guide development to suitable locations and at appropriate intensities and provide for higher densities only in areas where the public water and sewers and all the necessary public utilities as well as transportation infrastructure are available or provided. So again, we have access to public water and sewer. Site has 3 separate frontages on Woods Road, which is a street on the official map of the township. Then finally, there's the objective of planning for population densities in areas that do not exceed the carrying capacity of natural resources, especially groundwater, and the ability of the soil to sustain on-lot sewage disposal systems where public water and sewer are not available. Again, not necessarily relevant to this site, but I believe the design is sensitive to the natural features of the site to the extent that it can be. And for those reasons, I'd conclude there is no substantial detriment to the intent and purpose of the master plan and zoning ordinance. Rounding third here, gang, almost there. Finally, with respect to the question of advancing several purposes of the municipal land use law, I'd offer that the application advances purpose A, to encourage municipal action to guide the appropriate use or development of all lands in the state which promote the general welfare. Purpose E, to promote the establishment of appropriate population densities and concentrations. Purpose G, to provide sufficient spaces in appropriate locations for a variety of residential uses, et cetera. And finally, purpose I, to promote a desirable visual environment through creative design techniques. So without rehashing too much, in conclusion, the team has been listening. We've tried to take into consideration the township's feedback, both from the planner and engineer, to come up with what we believe is the best possible design and planning alternative. Again, we have a very unusual parcel, both in shape and area, that it's 6 times more than the minimum lot area requirement. It's a proposed use. The bulk conditions for which we're requesting variance relief are primarily all related to the specific element of the shared driveway design, which, again, for the reasons stated, is the better planning alternative. Tree removal will be mitigated beyond what's required. The site will continue to function well and provide sufficient access. And this is also just an opportunity to realize a negligible increase in uptake to the township's housing stock. And we've satisfied the negative criteria as testified to. So therefore, again, for everything we've discussed, it's my opinion that the applicable statutory criteria has been satisfied. Thank you.
Thank you. Mr. Mayor.
I have no questions, Mr. Chairman.
Okay, that was easy. Mr. Coyce.
Good evening, Mr. Behrens.
Behrens, got it,
Behrens,
yes.
thank you. And just clarification, because you were asking about the one lot. I don't know if there was some confusion in the way I had it in the
Oh,
table.
whether or not a variance was required, yes. So that was,
Yeah.
it was a question, not a statement. Whether or
Yes.
not lot 45.07 requires a lot width variance, because it exceeds 3 acres, and my understanding is that a flag lot above 3 acres only needs a lot width of 25 feet. So
So I could explain. The one wasn't intended to say, it's not implying variance. V, if it has a V, a variance, I have the one as a note saying, I was just trying to bring to the board's attention because when it comes to the minimum lot width, obviously a
footnote.
flag lot wouldn't meet it, right?
Well, right.
So that's why I was trying, I should say that differently. A flag lot doesn't have to meet it. So that's why I put the note in number 1 that the 25-foot is required for flag lots. So I just wanted to clarify to the board and to everyone else, I'm not saying that a variance is required for the minimum lot.
I think we said it was, so
Okay.
I wanted to clear the air.
Got
So,
it.
yeah, not
Okay.
casting white.
In my
I-
own professional opinion, I didn't believe it was
Okay.
required for minimum lot size.
I think your footnote actually helped me realize what,
I'm here to help
provide
for everyone.
clarity, yes. So I'll-
It's what we do.
I'll take you up on that.
That's what we
yes,
do.
yes. So, thank you for clarifying. Appreciate it.
Other than that, Mr. Chairman, I don't have any further questions.
Thank you. Board members? See a lot of head shake.
I have a topic that I mentioned earlier as far as, and it's in the economic report, on the affordable housing. The fees will be assessed by the building department and applied by to the Affordable Housing Trust Fund. I believe item 11 in Mr. Coyce's report says the affordable housing fee will be 1.5%, and that'll go to the Affordable Housing Trust Fund. And this may or may not be relevant, and I look to council to clarify, but we had a prior application that included 15 units of affordable housing in round 3. Will the amount put into the trust fund be equivalent to what the prior approved development was for 15 affordable housing units?
Not unless it plans on providing $3 million. The going rate pretty much is about, around here is about 150 to 200,000. At 15 units, you're looking at roughly $2.25 to $3 million. The bigger problem is we got an approved plan with credits approved for 15 units on this site pursuant to a specific application which was approved because it assisted the municipality relative to its round 3 obligation. It's in the approved plan. The court approved it. Fair Share Housing signed off on it. The township would have obligations, and I'm not totally sure that it can just be wiped away with another application. It may require further court approval and further court action regarding it, as well as how everybody's going to handle this shortfall. And I don't have to tell some of the members of the board that we have developers who are contending, among other things, that our failure to meet our obligations under round 3 is somehow a rationale for round 4, which I don't understand for the life of me. But leaving that aside, including one of those people who is in fact falling short of round 3. But this is another component. You know, there's nothing on the record right now that indicates why we're going in this different direction, other than the fact that the applicant now wants to build 5 $2+ million homes, where a application that Mr. Ogrodnik handled 4 years ago, I believe, for a memory care community is no longer has any value to it. So I would argue minimally that we need testimony relative to why and the testimony, by the way, can't come from Mr. Ogrodnik, who sort of tried to answer that question earlier this evening. But there are interesting legal issues stated by a lawyer. What a shock. Interesting legal issues as to whether or not you can simply say, oh, it's in the plan, it got approved, but we're no longer interested. It's your problem, Merry Christmas, because ultimately it becomes your problem, yours being the municipalities.
Let me offer my perspective and perhaps a solution. So I think one of the questions was, we've got minimum testimony as to why the changes occurred in just a 4-year period. Here we are in October 2025. I think if we look back 4 years to 2021, we probably all recognize that cost of construction has skyrocketed, inflation as well as interest rates. So to build anything, like Mr. Ogrodnik said, the cost of construction has doubled or tripled to really do
Mr.
anything.
Behrens, based on that alone, nobody should be building, because that's the argument we've been hearing. You might be a wonderful witness for the municipality when we get to round 4 by telling the courts that, oh, by the way, we can't meet our obligations because construction costs have gone up.
Well-
The issue was and is, and I don't think necessarily with all due respect, and I deal with your firm in a number of places, that the cost of construction in and of itself is a justification as to why we've decided to pivot, because there isn't a developer around who we have, and I think we're going to hear, some of us are going to hear shortly, that isn't going to tell me about how expensive things are and why things couldn't be built. And I don't see the courts right now saying to us, well, you know, that's a problem, but we'll let you all off the hook. Nobody, the mayor and Committeeman Lapani and I sat through the mediation with Judge Jacobson on the numbers. And I don't recall anybody saying that we're getting a break in Hillsborough or any of the other towns I represent, because construction costs have gone up in the last 5 years. Everybody recognizes that.
Well, let me, I did have more to say, so let me, when we get to the issue of the site being in the plan, so we did look at the plans, and the site is referenced in a single line item in both the third round housing plan, which is dated 2023, and your most recent plan, June 2025, which basically has the same line item. So it includes the site under the category of supportive housing for 15 units.
Based on
Well-
the approval.
Well, so
Well-
let me get there. Let me have a coherent, right. So if we go back to the approval, right, which was a use variance for a dementia care facility, is my understanding, the resolution doesn't have one statement about affordable housing. There's no commitment to provide affordable housing. There's no condition to provide a deed restriction, which is often the case. And I believe, I wasn't involved in that application, but my understanding is that the testimony and the granting of the use variance by the, not this board, but by the zoning board, was for a market rate facility. So all, if not most of those units, maybe there would be a 15% affordable set aside potentially, but most of the units were represented as being market rate and even luxury units. And the analogy I would draw is if you have an assisted living facility, all of those units would not be counted as affordable. Usually there's a dedicated 10% Medicaid eligible. Those units would be qualified as affordable. And certainly the applicant, while he got an approval, I don't believe is compelled to act on that approval. I don't think he was not party to the settlement agreement between the township and Fair Share Housing Center. So subsequent to his getting the approval, I think the township saw it as an opportunity to include it in the housing plan, which probably made sense at the time, and conditions change. And I think as long as the applicant's not bound by any commitment to have to develop the site in one way or the other, conditions can change and they can submit for an approval. And the application before this board, I would submit respectfully, is that it's for this subdivision application. But I do have a solution to your problem, because, or this issue, let's say, I don't want to call it a problem, this issue. And Mr. Burns, he said, or indicated, implied, our firm represents a number of, about 50 towns doing affordable housing throughout New Jersey. So very familiar with the new legislation, how all this works. When I was looking at the settlement agreement with Fair Share Housing Center, it includes the township's vacant land analysis. and it lists this particular site, which is Block 204, Lot 45.01, as contributing to the township's third-round realistic development potential. So on the one hand, the site's identified as vacant, creating an obligation, but it's satisfying that obligation, so it's a wash. It's a wash. The legislation and prior COA regulations allowed towns to recognize changed circumstances. This would be a changed circumstance where the developer is no longer proposing a development. I've seen in other cases where sites have opted out of a housing plan. They're entitled to do that. I've seen that with group homes and other types of developments where they just said, we're not willing to do the deed restriction. We don't want to be part of your plan for X, Y, Z reason. And that's allowed. So as much as developers want to be in the plan, others can say, well, we're not part of the plan. But again, I think the solution is, without arguing about whether it qualifies and this or that, is that it's simply a changed circumstance. So while it generates the obligation, it satisfied that. And I would offer that because it's a changed circumstance, it's no longer a feasible project, that RDP should be eliminated, and therefore the removal of the plan mechanism would also be a wash.
I don't want to make that argument. I'd
ju-
like
ju-
you to
just-
make that argument, if that's the case.
Just for the
right
record,
away.
for the record of the board, the settlement agreement the township entered into with Fair Share Housing Center is March 27, 2020. We ran, trust me, and those, I don't know if Mr. Coyce was, I can tell you that every item in this plan was run by the special master, was run by Fair Share Housing, was run by Judge Miller before it got approved, that there was a requirement, and Green Care Center was in it. And at no point along the way did anyone raise a flag with us, of all the people who reviewed it, that, oh, it doesn't have the deed restriction, therefore it doesn't. Trust me, for those of you who have not been through this, Ms. McManus and Mr. Gordon from Fair Share Housing don't give anybody anything. There isn't a break given, so they had to believe that this was actually a qualifying situation, and we had to provide the resolutions regarding same. So if Mr. Ogrodnik's client wants to make that pitch to Fair Share Housing and the special adjudicator that this is a changed circumstance, and by the way, the law is not nearly that clear. If you just declare yourself a changed circumstance, you're out. The requirement basically is if you can't make it work, you have to have an alternative. You don't get a freebie and declare it no longer. I don't have a problem with that, but I don't think it's this board's obligation. I don't think it's the township's obligation to make that claim. The thing is in the plan, and it's not like it's been a big hiding issue. Mr. Ogrodnik's office was part of this round 3 obligation, representing not Green Care Center in this case, but other parties in this case. And I think if the applicant wants to make that pitch, they should, but this board can't grant it in terms of a changed circumstance.
I just don't see how it's really relevant. I mean, typically we see developers saying, we can't build this is not feasible, but if you give us another 50 units, yeah, maybe we'll make it feasible. This is an application for a residential subdivision. We're not proposing 65 townhomes or 100 townhomes. The courts, I think, are pretty clear, unfortunately, that, and I point to in readoption of Monroe Township Planning Board 442 NJ Super 565. And it's an appellate division case that talks about really,
A year on that, by the way?
what's that?
What's the year of the court decision?
2015.
Thank you.
And it held that it's the municipality, not the private developer, to provide that obligation for a realistic opportunity for the construction of affordable housing. So I don't think that we don't owe 15 units because we're applying for a major subdivision and we meet the requirements. This wasn't rezoned. The settlement agreement in 2020 included this site before the approval. And I think that's relevant as well. But it's not really up to a developer who says, you know what, I don't want to build whatever the project is. I want to go to a conforming use. So unfortunately, I think it's the township's obligation to make any revisions that they wish to make, or in all likelihood, address it in round 4. And I noticed today, as I was reading, that your case from 2015, it's still in litigation. The round 3 is still in litigation. I just saw a motion being filed by the Sherwood Tract for a hearing, later this month.
It
So,
has nothing to do with the affordable housing obligation. It deals with an issue of whether or not the township has an obligation to pay for additional costs on a litigation. And everything right now related to round 3 comes under the 2015 docket number, but it has nothing to do with the round 3 obligation. Our numbers are met on Sherman, at least on that phase.
but I don't see any contractual obligation. I don't see any resolution compliance. I would submit that even if there was a resolution that said you had to have a set aside of 24%, that you could compel a developer to construct a project or consider that they somehow owe those units. So this is a simple application. I understand that there's impacts to your round 3 plan, but that's not really this developer's problem.
So question. So how was this property?
What?
What? No, how was this property entered into the round 3 affordable housing plan?
Unilaterally, without the consent of the applicant.
I asked my attorney.
How is it? The parties were aware that a memory care community that met the obligations would be considered as part of the township's plan.
Did they have the opportunity to object? Of
I'm
being
unaware,
included?
the plan was well documented, it was published, there were parties involved. Was this specific party given an opportunity to object per se? No. But the plan was public, it's not like it was hidden, it was set forth in the plan. And I go back to my earlier comment. As members of the committee on the board are aware, everybody and his brother related to this reviews these plans with a fine-tooth comb. Most notably, the group we entered into an agreement for back in March of 2020. Forget this round. Round 3 was as equally problematic as round 4. So again, Mr. Ogrodnik's comment to you basically is, approve my client, and it's the township's problem to deal with the 15 units. That may be a decision you all want to make. But understand that there's an impact because the developer no longer wants to be obligated to a prior approval that was granted. And the argument apparently, because we have no testimony, is that somehow changing construction costs now generated versus the fact it's conforming. It's always been conforming. The zoning, correct me if I'm wrong, Mr. Coyce, hasn't changed on this property in years. So when the applicant came here back in 2020, 2021, seeking the item, this board granted the approval along, I believe, with the zoning board to build a memory care facility that it now apparently no longer wants to build. And if it had no impact on the plan, I don't think it would matter one way or the other. It would be up to the board whether they're going, but there is an impact. And basically, the developer's comment to you all is it's your problem. Not necessarily the board, but it becomes the township's problem.
I would just say that I'm just quoting an appellate division decision that holds
Well,
that. It's
I
not,
would
it's
be
not
more-
nothing personal.
Which,
Right, but I would be
by
more
the way,
interest-
predates, if my recollection is correct, Judge Lavecchia's decision relative to round 3.
How does a municipal obligation shift to a private developer? I mean, it happens all the time where a developer, he could just wake up one day and...
Can you name me a court case that happened, or?
I could.
I mean,
could
because you
think of-
don't, I don't want to hear generalities on this. I want some facts, because right now, what I'm leaning towards right now, because the ask of here is going to be to weigh judgment or overturn, I think, what another board did, the zoning board. I'm almost inclined that we make this part of a conditional. If we decide to grant approval, it would be part of the condition that this needs to be resolved with fair share housing.
And the court.
Well, that's why I mean the court, fair share
No,
housing.
fair
and the
share
court.
housing
Yeah, I know.
and the court.
Well,
So-
they are the court.
No,
township-
well,
I know.
I think,
But they're-
I think Judge Menon would tend to disagree with you on
yeah,
that
I
one
agree.
for the
But-
moment.
but-
Mr.
because-
Chairman, the township designated this site unilaterally before the application was heard.
I think that
Property,
makes-
well, I was
Sorry, go on.
sorry, I was going to say, properties get into affordable housing plans before their applications are approved.
I don't
mean,
know how-
Round four's
I
got
can't-
three or
I can't-
four
I can't-
properties in there, and those
I can't
applications
answer
haven't
that
been
argument
approved.
because it didn't find its way into this plan unilaterally. It found its way into the plan because there was a basis for putting it in the plan. There was some kind of approvals for this plan. It didn't, and it not only did not end up that way, it had to be, we did not, we sent a bunch of documents to Fair Share House. We didn't even, we sent Fair Share Housing a table, and they said, looks good to us. That I can absolutely guarantee you did not happen. They
I'm sh-
never said, oh, we see this list here, and trust me, we literally had to backtrack everybody in this table. There is a multitude of, for those of you who I think have a copy, paragraph 7 of the settlement agreement, a multitude of places where we got units and credits for what I would call traditional development housing, whether it was 1 unit, 2 units, 5 units, 15 units, et cetera. We had to produce proofs for all of these. Otherwise, it wasn't going to get approved. So somewhere along the way, there were proofs relative to same that everybody was satisfied with, and everybody knew what it was. And miracle of miracles, a memory care facility of 15 units just somehow gets approved, whether it precedes or doesn't. So I'm not sure how anyone was, quote, surprised, close quote.
We weren't a
By law.
party to the settlement agreement. I mean, you can't bind a developer unilaterally. I mean, that's basic contract law. There's not like there's a redevelopers agreement or a developers agreement that requires this set aside. What's before the board is a simple subdivision. We would be, if the board would rather have 65, 75 townhomes there with a 24% set aside, we would absolutely consider that for this site. I mean, that would be, probably preferred by the developer. We felt that this plan was consistent with the zoning, and we could make a fully conforming subdivision plan.
I've sat in on several hearings, and I've gotten wound up a lot, so I don't appreciate your comment about what else would be suitable for this, 65, 75 units. I don't appreciate the wise-ass remark.
It's not.
Yes, it is. And I've sat in and I've taken it in the shorts from the court, from other developers, sat there and heard it. And so I raise this for a reason, that we're getting raked over the coals for not being able to meet round 3. And here we have something that's taking something and making round 3 worse. That's the only reason I bring it up, and I'd like it resolved. And so, one way or another, we got 15 credits. I don't know if it was 15 units, 15 credits, right? We got
15
more.
bedrooms.
Yeah, so that's why I bring it up. I mean, yeah, you have a simple application here. I think we're all ready to approve it, absent this issue. Honestly.
I'm sensitive to your concerns. We represent a lot of adjacent municipalities that are going through the same concerns. But again, this is what's before this board. We stand on our merits of the proofs that we've demonstrated to have a conforming major subdivision for single-family residential and a residential agricultural zone.
What I think, just for interest, because I think we're going to continue discussing this a little bit later, so I'd like to open up to the public, if no board members have additional questions of the
I don't.
applicant's planner to allow the public to come up and cross-examine the applicant's planner on his testimony. And, no, still open to public.
Okay.
Yeah, well, we're not there yet. I don't think. Yeah, okay. We do have to close it, right? Before we go to the last bite? No.
I have a question for the planner. And it's, once again, I'm just really curious your opinion. You know, with all your experience, you know, in planning and you know, in this industry, what is the highest and best use for this parcel?
That's permitted? That's a loaded question. So if you look at the zoning ordinance, I didn't memorize all of the permitted uses, but certainly detached single-family housing. So if you're looking at strictly by right use, that's probably the highest and best use. If you wanted something like a rezoning or a use variance like was previously granted, you could probably get more value out of it that way. So I think there's two ways to answer it. One is, again, adhering to the current zoning, single-family development. If you wanted more flexibility, you would ask for, again, use variance or rezoning to grant some other type of development, likely residential, given the context. You know, it wouldn't be, I don't think it'd be suitable for industrial or something like that, or a Wawa, you know, given the shape, et cetera. But 12-acre site, right? I mean, it's 2-acre zoning, but you can do a lot with 12 acres. And that's not the threat, that just, you know, from a value perspective,
Yeah.
it is what it is.
Thank you. I was just curious, wanted to
That's a fair
answer
question.
the question. Thank you.
Mr. Chairman, just for, I believe I don't recall whether it was Mr. Ogrodnik or Mr. Ford commented that the proposed sale price of these homes was somewhere around, what, 2.3 million?
I mean,
Somebody proffered the number. I'm not sure
Yeah.
whether it was you.
It was
or whether
me.
it was mine.
Yeah.
Okay.
Based upon our discussions, and market rate, yeah, we're looking at a range for single-family construction, for new construction in Hillsborough to be in that range.
If you assume for the sake of this discussion that they are all assessed at $2 million, of which there are 5, and the requirement is 1.5%?
Correct.
You're talking $150,000 added to the Affordable Housing Trust Fund. So just keep that in mind. Hmm.
So, as the mayor said, you know, we have this number that we're obligated to build in round 3 of X.
Mhm.
And unmet need would come into play then if these
Well,
units would
actually,
go away.
we have no
have none now.
unmet need at the moment,
But this would qualify as an unmet.
potentially.
Right, and then we would have to go out and find
Mhm.
replacements for this, right?
Somewhere, somehow. I'm sure Mr. Ogrodnik has a comment.
But do we need, and I'm just asking this rhetorical, since it's in our plan, and do we need to have fair share set at Allen Court allow us to take it out and put it into an unmet need?
I would argue that, yeah.
So therefore, it would be almost a contingent approval that would have to come before the courts.
That's, yeah, I think it's got to be conditioned.
And then at that point, if it does or doesn't, you know, decision is made on that after that. We may have to come back here.
Just for clarification, would that be an amendment to the third round settlement that's in litigation, or with respect to?
The third round,
is
let
not
me be absolutely abundantly clear. The third round is not in litigation in terms of any agreements. What's in litigation right now is a claim made by a developer for additional funding from the municipality for a shortfall in building affordable housing. That's the issue in litigation. not the town's plan, not the town's obligation, not the town's agreement, nothing of that sort. That's the issue.
Correct.
Do you need a break? Okay. We are going to take a time out to give our stenographer a 10-minute break. We'll reconvene at 10 after 9.
Fingers are burning.
There we go, we're back. All right. I like that, man. Huh? It is. Okay, we're back in session. Mr. Bernstein?
Nick has another witness.
Yes, I'd like to introduce Rajit Singh. He's the managing member of the applicant, Green Care Farms LLC. Can you get sworn in, please?
Yes, I do.
I'd pull it closer, sir.
Rajiv Singh, R-A-J-I-V-S-I-N-G-H.
Could you give us a little bit of background of what you've done over the last 30, 40 years, and how did you end up here in Hillsborough with this property?
Well, my background, my formal education is in engineering, and while I was in school, I stumbled upon technology. I started a tech company, and then I sold that in 2001, and then I bought a Keller Williams real estate franchise, which is located in Montgomery. And actually, I lived in Hillsborough for a couple of years in the mid-90s, prior to moving to Montgomery. And then I own a title insurance company, which I've been in that business since 1995. And I've been in the mortgage industry since 1983. So I haven't been a developer, but I have been. I've as a lender, I participated in projects, construction projects, so I have a little bit of knowledge of that. Now, I have a family history of Alzheimer's. Both my paternal grandparents had Alzheimer's. My father had Alzheimer's. My mother-in-law had vascular dementia. And so I always felt that, you know, my dad was very sick for a very long period of time. So I really wanted to do something about that. So I was talking to a friend of mine, Jazz Bajaj, he's chair of the ICU and emergency room at Penn Medicine in Plainsboro. And I said, you know, these guys that have Alzheimer's, we stuff them into memory care wings and you know, we sedate them and we put them in wheelchairs and we treat them like animals, and they're, you know, it's horrible. There's got to be something better. So he said, you know, I have just the person for you to talk to, and his name was David Barilli. He's my partner, and Dave is very passionate about end-of-life care for Alzheimer's, and I have the gene, by the way. So Dave, and he's one of the top geriatric physicians specializing in Alzheimer's in the world, actually. And so we started talking about this about 11 years ago. So he told me and explained to me about the care that takes place in Europe, specifically the Netherlands. The Dutch have a genetic disposition for Alzheimer's, as do the Japanese. So he said, you got to go over there. So I went over there, and you know, I took a trip there, and I visited some what they call care farms, and I was fascinated by it. And I, over the course of the next couple of years, I spent about 6 months visiting different care farms. And we decided to start looking into doing something. So we came up with the concept of Green Care Farms, which instead of sedating Alzheimer's patients, you put them in an environment where you know, in a farming environment, not hardcore farming, but you know, where there's plants and there's greenery and there's small farm animals like chickens and baby goats and things like that. And instead of sedating them, and this has been very successful in Europe. So Green Care Farms was for public benefit. It was not a for-profit organization. And, I've always been in private industry, so I've never been involved with the bureaucracy that takes place. And, it took us a long time to figure out what needed to be done. And when we started on this, I was in my late 40s. And by the time I burned through, well over $1 million, and, we aged, and we just, Dave is not entrepreneurial. He's very good at what he does, and I love him. And I just did not have enough left in me to build it. And also, if you look at the economics of it, this is not a Medicare and Medicaid facility. This is 100% private pay. And the occupancy rates have gone down significantly. That's one aspect of it. And then also, if you look at what the government is trying to do when it comes to Medicare and Medicaid, they are trying to have their policies as such that reimbursements are done. They're encouraging Alzheimer's patients to be taken care of in the home. So that, with the rise in construction costs, it's just, and then plus, I'm at an age where I can't do it anymore. I just can't. I just don't, and I'm going to have Alzheimer's, So, I'm 60 years old now. I have to look at the, you have to be, at some point you have to say, hey, is this feasible? Am I gonna? It's gonna take. It took us this long to get to where we were, and it's gonna take 3-4 years to build. So, do I want to be doing this for the rest of my life, right? And then I have some other health issues that I don't want to get into. And then, so, I'm just trying to salvage whatever I can out of this. And that's why, we tried to sell it as a memory care facility. I'm in the business, right? I have over 100 agents. We tried to sell it as with all the approvals in place, and nobody wants to touch a facility that only has 15, if they're going to do it, they want something big. And we were never about making money. We just wanted to do something that was really revolutionary, but I just can't do it. I just can't do it. And my partner he's not in a position to run a facility like that. So that's why we kind of had to, we had a lot. We had to do what we could to get our, whatever little we can get out. I'm well into the 7 figures. So I'm not going to forget about the time and effort that I put into it. I put my life into it because I really, really wanted to do something special. But that's where I'm at. And, I was never a party to any type of COA. And I don't see how this facility, even though it may have been approved for, a community home, I don't see how this, in the spirit of COA, I don't see how this fits in that. But I was never a party to anything about COA. The first time I heard about it was when, a few months ago, when I got this letter that, there's some COA issues. And I'm like, I never heard of any COA. Nobody sent me a letter. I never agreed to anything like that. And I don't think it's fair either, So that's kind of the history. If I was, 20 years younger or 10 years younger even, when we initially started, we figured, hey, we'll have this facility up in a year, I didn't know, what it took to go through NJDOH, DCA, and all the other stuff we had to do. It was just a monumental, journey that, You know, I mean, I wish I never went through it, you know, but at this point, I'm at where I'm at, and I'm just trying to salvage whatever I can, you know, to, you know, mitigate as much as my loss as I can. I'm not developing this myself, but I think for the community, I mean, to have $2 million houses in that area, it's going to be good for that area. You know, all the houses' values will go up there. So that's.
Could you just touch on some of the financial considerations related to the construction costs, as well as some market conditions related to demand for this particular product?
Yeah, I mean, listen, the cost of the carrying cost, the interest rates have gone up from when we were originally doing it. And listen, if we would have built the facility, I would be bankrupt today. There's no way. You could not. I mean, if you're looking at having 5 or 6 people there that are paying $600-700 a day, you know, you got to have 24 hours a day. You have to have a RN there. There's no way that you could. It was financially feasible. The construction of it was, you know, it was a single-story facility with 15 rooms, 15 bathrooms, a luxury kitchen. It didn't make any financial sense. We just couldn't do it. And like I said, you know, occupancy rates, if you go to any of these type of memory care facilities, they're at all-time lows because, you know, there's changes, and people can't just can't afford it. You know, it's not. It probably was it probably was not planned well. And you know, I don't have any healthcare background, and my partner had no entrepreneurial background, so it was kind of a bad plan from the very beginning.
I have no further questions for
Okay.
Mr. Singh.
Board members? Okay. Anyone from the public? No, we do have someone. And when you come to the mic to your right, just please state your name and address for the record, please.
Judy Lavoie, 255 Woods Road. Judy Lavoie, 255 Woods Road. I'm not against developing the property, but why can't we just do what you could do on the property? Why do we got to change things? We make rules for a reason, don't we? So why do we need variances? Just look at the property, what you're qualified to do on it, put it on there. Why do we got to squeeze 5 on there? Just do what you could do, what it could be approved for,
So-
without changing the rules.
Just ask a question of the testimony here. So I know you're kind of doing a general question, which would be later, but this part of it is just ask a question of
Okay.
maybe what he said.
You understand my question?
Yeah, I think we could build 6 houses on there. That's
Okay.
by right.
Oh, by following, like, all the ordinance, following all the proper ordinance?
I mean, I think it's like it's two per house. You need 2 acres.
5, I believe it's 3 acres for a flag lot?
Well, we had provided on A4 a conforming plan that didn't have any variance relief. It would be fully conforming, which would be an as-of-right approval.
You have enough road frontage for
If we-
200 foot for each house and
Yes,
stuff like that?
so
You do?
we provided a concept plan that would be for a cul-de-sac that would
Oh,
provide
then
the
you'd have to
necessary.
build the road, right? And the township
Correct.
would have to take care of the road.
Now, the township wouldn't have to take care of the road. Township, typically in central Jersey at least, municipalities are not accepting public dedications of small subdivision
Well, I don't know-
roadways.
I don't know all the rules, but
Ogrodnik,
That's
can we
my-
maybe have Mr. Ford come up and put up A4,
Sure.
which I believe is what your argument is a so-called compliant plan? Correct, Michael? The last one, A4. But let him put it up on the
I need
screen so
glasses, I
everybody.
can't see that.
Can you put it up? You're a big help.
Here. Give her this.
Let the planner
Well, then
come.
I was misunderstood. I thought there's certain rules. Because of the road?
Correct.
Okay, and what about over here?
Same thing.
Where's the road?
There's no road. This has frontage on Woods Road. This has frontage on Woods Road. And this lot here, with the 25 feet, is a
T coming up.
flag line.
Matt.
No, not John. The witness, in case he's actually has to answer a question.
Unfortunately, we're out of battery power today.
I understand that. I'm more interested that you're out of
Well, that
a
was
witness
my
there.
thought.
Okay.
Yeah.
But you don't have to get up yet. If there's nobody to ask you a question, you'll be good.
I guess not.
I see no takers. All right,
Mr. Ogrodnik's last words.
yep. Closing argument?
I don't really have anything to add. You know, I can tell you that the discussions that I have in our office every day relate to the problem that's facing pretty much every municipality, which is that projects that from round three that didn't get built. And that's something that the courts are going to have to address. Fair Share is going to have to address it. But for purposes of Rajiv's application, we're here to propose if the board wants a fully compliant variance-free application, or looking at the feedback from the professionals to incorporate some changes that we think are good changes. But we defer to the board on the design elements, what they would prefer. We think, I would wholeheartely agree that, you know, when you look at subdivisions this small, you're typically not getting, you know, a large builder, you're getting a custom builder. And I would submit that this type of infill development is the ideal type of development for Woods Road. These are going to be beautiful, private, custom homes, and I would ask the board to approve that. We certainly have no problem advising the court or Fair Share that this project is no longer feasible, and therefore there could be an adjustment related to the vacant land that was included. But again, we're really here just on a relatively simple 5-lot subdivision, and you know, unfortunately, we can't you know, meet any type of credits with the proposed use because single-family residential. But we can do our part and comply with the ordinance and submit a considerable sum of money, about $150,000, to the COA fund, and hopefully these factors are, you know, I would just ask the board to just look at the application without considering the impact to potential round 3 adjustments related to the Fair Share settlement agreement.
So this is the time where the public gets the last bite at the apple. If anyone from the public would like to just to give their thoughts on the application, you feel free to come up. Okay. So with that, motion to close.
So moved.
All in favor?
Aye.
Aye. Okay, Mr. Bernstein, you want?
I think you've gotten a certain amount of testimony relative to the change in conditions. I frankly think, based on what we'll have to deal with, that the board needs to maximize, or let me rephrase it, minimize the changes in the plan, i.e. variances, waivers, et cetera. I think all the trees that need to be on the site need to be on the site, if not removed, replaced, that the plan be as compliant as possible, and the applicant has produced what he believes to be, subject to Mr. Coyce and Mr. Mayhew's reviews, et cetera, a compliant plan that doesn't require the various variances. Correct me if I'm wrong, Michael.
I don't believe there's any variances if we go with the alternate design. Again, we were taking the lead from your professionals on those
Yeah.
design changes.
Which is, rather than the shared driveway, the cul-de-sac, which would be the requirement of either the homeowners who own the property themselves or a homeowners association. We'll have to deal with the other issues, and to the extent the applicant is willing to and participates in such to assist, we'll deal with it accordingly.
Board members, deliberate.
I'll lead off. Since I was here in 2020, one of the few, maybe Mr. Peason was here and Chairman, I think, one of the mayor was here, at maybe just beginning. I can appreciate the trouble that Mr. Singh has created or encountered in developing a program or an original application of what he thought was a love of trying to do something for the good of the population, and maybe didn't didn't look at the plan as closely as from a business standpoint as he thought of, and as the things started to unravel, he realized it wasn't feasible economically. But the state of New Jersey puts us in a bind, right? And Mr. Ogrodnik is fully aware of the affordable housing mandate that is imposed on Hillsborough Township and every municipality around. And we have to meet that number or fear builders remedy lawsuits, meet compliant plans, and we struggle and we meet with interveners and we go through hours and hours of time to try and come up with a compliant plan. And then even though we have a compliant plan, we have to seemingly chase down our builders who are ready, willing, and able to build something to actually build what they said they were going to build. This plan in itself is a nice plan. I'll give you, it's 5 nice homes. It's going to add value to the township. And I am angry in the fact that we have to go back and now find lots to meet our obligation. I don't necessarily blame Mr. Singh or you guys for that, but the fact of the matter is now we, again, are moving the goalposts. And the mayor and I have talked about this, and a former mayor, the chairman, has dealt with this. It's just frustrating, and I hope we don't come across that we're have any animosity toward the applicant. It's just frustrating, especially in this round and what we're dealing with right now. And quite honestly, the people of Hillsborough are frustrated with the affordable housing and all the stuff that we have to deal with. So I don't want to say that we're picking on you, so to speak. It's just we're frustrated, okay? I think the plan is good. I think the application with the shared driveway as opposed to the big road, in my opinion, is the better application, as opposed to a large road. I think from a maintenance standpoint for the HOA it would be easier. I would say that I would make a motion to approve that plan as long as all the waivers were met, or no waivers, meaning all your tree obligations, all your things that you need to do. The one variance that we're going to have to give you for the shared driveway, and the $150,000 or whatever, the 1.5% that you need to pay to the fair share. What I would ask, if we need you, and fair share is asking us why, that we have that testimony that we can use to why you changed the application, and that why we are now short those units. So that would be my motion.
I'll echo Sean's comments. And with that, I'll second that motion.
Okay. So we have a motion to approve the application along with everything that was agreed.
The application with the shared driveway between the two houses, the responsibility for the maintenance of such shared driveway shall be shared, no pun intended, between the homeowners, and that it will be in the resolution as well as in any deeds for those properties, that the property owner will replace any and all trees replaced on the property, that it will comply with all the items that is previously indicated, it will comply to as well as conditions to pay the applicable Affordable Housing Trust Fund money and to assist if required by the township to address any issues related to the changing conditions that brought us to the situation at hand.
Okay.
Michael? Anything last word?
No?
Okay, very good.
So with that, may I have a roll call, please?
Mr. Flagg.
Yes.
Mr. Vitale.
Yes.
Ms. Smith.
Yes.
Committeeman Lapani.
Yes.
Mayor Ciccarelli.
Yes, and I look forward to Mr. O'Gronic's cooperation as we deal with their share.
Certainly.
Vice Chair Peason.
Yes.
Chair Sarachi.
Yes.
Thank you very much.
All right.
Mr. Chairman, as I indicated previously, and I will confirm again for the record, next week's application for Harvard Way, which was to come back, if you recall at the last hearing, and Mr. Ogrodnik probably should sit in so he gets another round of whatever, is that a motion was made by Mr. Afrin, who was here at the last hearing, seeking intervention on behalf of individuals as well as the Green Care community. That motion is still pending. His Honor was supposed to rule on it tomorrow. Subsequent to the filing of the motion and prior to hearing from the court, my office was first advised that Ms. Angeli's father was basically close to and apparently has subsequently passed away. She is therefore unavailable to be here next Thursday, and she's handling this issue more than I am in terms of this matter. In the interim, late this afternoon, we received notification from His Honor on two issues. One, he wants to hear oral argument, and his court calendar is so full on tomorrow that he has no time to hear it. And B, he's notified us that at 2 p.m. next Friday, he will hear oral argument on Mr. Afrin's motion to intervene and Mr. Ogrodnik's, Mr. Flynn, I'll speak, motion to an objection. So until that issue is resolved in terms of who's in and who's out, and I also suspect based on Mr. Brooks' comment, we're going to try to get some clarity on that item about the public input. There is no need for next Thursday night's application for Harvard Way. I don't know if there's anything else on the agenda.
No, there's nothing else on the
And
agenda.
we can probably, any resolutions could probably wait. The next meeting is what, November 13th?
All right, but we also have a business meeting
So we don't
on the
want on the
calendar,
6th.
too.
Can you just carry Harvard Way to that date?
We're going to carry Harvard, I'm going to recommend we carry Harvard Way to November 13th without further notice. But equally in addition, whatever else we have to bring before you, we may have some resolutions, et cetera. I would remind, for lack of a better phrase, as we are referring to them, the Fab Five, that if there are problems in terms of your schedule over this meeting, that one, or the following meeting, that you can please advise us. Of course, in the absence of all five of you, and I know Bob is not here tonight to defend himself, there is no quorum. So at least for that application, there may be a quorum for others. I'm assuming there are other applications. And the board may end up having to deliberate over a period of time. But, you know, to the extent we have no control over next Thursday. That's where we are.
Okay.
So the first item, Mr. Chairman, is a motion to continue the Harvard Way application to Thursday, November 13th, 2025 at 7 PM or soon thereafter, as the matter may be heard without further notice.
Okay, is there a
Excuse-
motion? Oh, sorry.
I'm so sorry. So November 13th, we have the Durling application. Then there's November 6th that's open.
I thought I asked when the next meeting was, and the words I heard were November 13th.
That was
That
my
might-
fault. I thought that was the next one.
We have a meeting on the 6th.
I could double check. That's what mine is showing up.
I don't think there is one. I only think there's one on the 13th.
Could be wrong on our
David.
list.
Yeah, it's on the 6th.
Yeah, November 6th is open.
You have a problem? Okay, why don't we carry it to November the 6th without further notice, and Mr. O'Grady can go home.
So moved.
All, we gotta do roll call.
Yep.
Roll call, please.
Thank you, Michael.
Ms. Smith?
Yes.
Committeeman Lapani?
Yes.
Mayor Ciccarelli?
Yes.
Vice Chair Peason? Yes. Chair Sarachi?
Yes. And then I
Sorry,
know
who was the motion and second on that?
Ms. Smith,
Lapani, Smith.
Thank you.
and I know we have a business meeting scheduled for the 23rd. Is there a motion to cancel the business meeting?
Maybe. Maybe.
Maybe.
So moved.
This is a motion to cancel both the October 16th and the October 23rd meetings.
No, we just did the,
I thought you said you want to keep the 16th open in case we have any kind of work that we need to do.
Yeah, let's leave the 16th, just the 23rd then, in case we got a resolution, though I doubt.
Do you have resolutions
Well,
in your?
I don't believe we have, it took a lot out of us to produce that
250.
245-page resolution you all got.
I think.
I would ask, let's start with it. Motion to cancel the October 23rd meeting.
Business. And
I
there
believe
was.
Mr. Lapani made the motion.
Yes.
And then-
Ms. Smith seconded. All
Okay,
in
roll call,
favor?
please.
Aye.
Oh, aye. Okay.
All right, Mr. Chairman, I would ask the second motion to authorize the chair to cancel the October 16th, 2025 meeting if he, in consultation with my office and Mr. Coyce's office, determined there is no need for that meeting.
So moved.
Roll call.
Mr. Flagg? Yes. Mr. Vitale? Yes. Ms. Smith?
Yes.
Committeeman Lapani?
Yes.
Mayor Ciccarelli?
Yes.
Vice Chair Peason?
Sure.
Chair Sarachi?
Yes.
All right,
Okay.
what do we have on for the 6th right now? Anything?
It was blank. It
Okay.
was nothing. Well, I mean, now officially Harvard.
All right, so,
We will endeavor to advise the board, once His Honor makes a decision, what the plan is, because, as I said, I don't know what he's going to do or not going to do until he renders a decision. I am hopeful that he will render one on the 17th, but I wouldn't count on it.
fair enough. All right, so with that, I will entertain a motion of adjournment.
So moved.
All in favor?
Aye.
Aye, we're
Aye.
adjourned.
Phillies are done.
Get that out.